Good afternoon and welcome. Thank you for joining us for the final round of the Domenick L. Gabrielli National Family Law Appellate Advocacy Competition. My name is Rebecca Novick, and I am the Executive Director of the Moot Court Program here at Albany Law School. As members of the Moot Court Board, our mission is to provide inter and intra-school competitions that allow for student growth and development in the areas of legal research, analysis, writing, and oral advocacy. Additionally, we do provide students with unique networking opportunities and that gives students a great sense of accomplishment, teamwork, and school spirit. We've certainly seen some enormous school spirit over the last 2 days here at the school as we've watched teams from all over the country compete and proudly represent their institutions. So first, we're going to hear from our Dean and President of Albany Law School, Dean Alicia Willett.
Hi, everybody, and hi, everybody who's on Zoom as well. Congratulations to everyone in this room for their participation and to all of the competitors for what you have managed to achieve over the last couple of days, and for our incredible Moot Court Board, what you've achieved over this year. This whole weekend has gone so smoothly because of all your work, with the exception maybe of a little bit of snow, but you know, it's March in Albany and we have teams that are here from Texas and California and Florida, and you know, we wanted to give you a little bit of flavor. I hope that the competitors, that to our finalists and to those who competed earlier, that you get the chance to go outside, maybe make a nice snow person or have a little snowball fight before you leave Albany, because snow is special. I do want to do some thanks. I want to start by thanking Rebecca, who chairs our Moot Court Board. You've been working tirelessly and many competitions. Thank you so much. I want to, I don't even know how to do this, but a special shout out to Emma Salazar Blake, who wrote the problem, came up with managing all of what we did today. I've talked to a number of judges. I had the privilege of judging 2 different rounds earlier. What a terrific problem you wrote. You wrote a problem that is realistic, right? It's really fact driven. It's got interesting legal issues. It was well balanced. All of the judges that I talked to said, you know, it was really nice to judge because we weren't saying, man, your argument's terrible, but the arguments were really there. And that's a really hard thing to do. It was well written. It was well received. So can we all give Emma a nice round of applause? And Emma's family is with us today, and we know that you supported her every step of the way. So to Emma's family, thank you very much. It's family law. I also want to thank the competition associates, Joseph Anase and Noah Chase, the faculty advisor for the Moot Court Program. I think she's going to be here. She may be on Zoom. Professor Kanika Johar, the faculty advisor for this competition, and it was her first year doing it, Professor Melissa Brieger, who is our family law specialist. I want to thank all of the judges, all of the bailiffs, all of the Moot Court Board for everything you did. I was just teasing them, saying they've been here for 36 hours straight. It feels that way, doesn't it? But it is just such an honor to host a national competition for Albany Law School, and to host the family law competition at Albany Law School makes so much sense. We are a place where family law really, you know, New York leads the nation in a lot of family law issues, and it is our graduates, Albany Law graduates, that wrote a lot of these cases that you are relying on, and that includes the late great Domenick Gabrielli, for whom this competition is named. He started his career as a judge in the county and children's court. And if you read his life history, he talks a lot about how hard issues involving children are. And we all grappled with that with this problem. Issues involving children are hard and important. And I hope that the competitors are going to continue to do this work, because what we saw was extraordinary skill, extraordinary compassion, extraordinary emotion. And I know you're dying to get to the arguments and have me sit down. So I will stop talking, but I welcome you all to Albany. You've been here. I hope you've had a good experience. And to the competitors, just take a moment. To the finalists, you're going to remember this for the rest of your lives. You did something extraordinary. This will be your seventh time arguing this, and you're going to be arguing before a panel of some of the most esteemed judges around. Whatever happens, you're extraordinary, and you deserve a lot of congratulations. So good luck to both teams.
Thank you, Dean Willett. So I'm just going to echo our dean here. And for some of the competitors that have been around all weekend, this might sound familiar, but there are some people who deserve to be praised way more than just a handful of times. So I would like to thank my incredible peers who have dedicated an enormous amount of time and effort into making this competition a reality. Again, our competition chair, Emma Salazar Blake, and her two associates, Joseph Aeneas and Noah Chase. Not everyone realizes how much work goes into these competitions, especially hosting a 2-day competition for students that we have never met before. So under the guidance of our competition advisor, Professor Melissa Brieger, Emma has exhibited tremendous creativity, persistence, and intellect throughout the problem writing process, which resulted in an interesting, relevant, and challenging problem. Emma, Joe, and Noah have spent an incredible amount of time organizing every last detail of this competition, from reserving rooms to tirelessly recruiting judges and bailiffs, including this morning, and navigating last-minute challenges, like the dean said, our impending snowstorm that we dealt with today. This team has proven to be extremely dependable, and I did not worry for one moment that they would not be able to deliver an incredible competition this weekend. I would also like to thank our entire Moot Court board and our faculty advisor, Professor Kanika Johar, who have exhibited tremendous flexibility, adaptability, dedication, and just general positivity and good vibes all around throughout planning and executing this competition this weekend. So really, thank you, thank you, thank you. Now, please join me in welcoming the National Family Law Competition Chair, Emma Salazar.
Hello. I hope that all of your rounds went well, and congratulations once again. For those of you joining us for the first time, as you heard, this competition is named after Domenick Gabrielli, who was an Albany Law grad, the class of 1936, and he was the former Associate Justice of the New York State Court of Appeals. Judge Gabrielli's daughter, Veronica Keegan, will either be watching live tonight or watching it again as a recording. I haven't been able to see if she's here tonight. This is our 35th year of hosting national students for this competition, and congratulations on making that 35th year. So far, these two have been participating in 2 days of rounds. They've spent months preparing for this, hard work. Every team prepared an appellate brief, and these two are the ones that successfully argued in all of the elimination rounds. I wish you both the best of luck. I know you want to get to it, but I also want to extend so many thanks. But I hope you've enjoyed this experience as much as I have. So to start my thanks for all of the people that made this competition possible. I could not have done it alone. To begin, I want to thank all the judges that gave up their Saturday afternoons to judge the semifinal round. Dean Alicia Ouellette, Judge Philip Cortez, Judge Carl Falatico, Judge Michael Lynch, Judge James Gerald McAuliffe, and Judge Silverman. I also want to extend the biggest thank you to Professor Melissa Brieger, who has been my advisor throughout this process. She has been supportive, thoughtful, enthusiastic. She's given me so many pointers and ideas, and it was a pleasure to work with her and an honor. Professor Brieger, if you'd like to. Thank you very much. Want to say a few words?
I don't want to take too much time. Congratulations to all of you. As you know, from my talk last night, this is my first time doing this, even though family law is near and dear to my heart. And it was because of Emma that I was convinced, and she made it just such a joy and such a pleasure. And it's been wonderful to kind of see these facts come alive, and it's been really exciting. So I'm going to repeat thanks to Emma, of course, to our court folks, to Professor Jahar, to our dean, Teresa Colbert, the staff. I'll keep going on and on until they come to pain. But I know there's more important things to worry about. So thank you so much, and thank you all for being here.
I'm also going to thank Professor Kanika Johar, our board advisor, not only for her personal guidance, but also for your dedication to the board overall. I also want to thank Rebecca Novick, our executive director, for her guidance late at night, her wisdom whenever I had a question, and her support throughout this weekend. I also want to thank Teresa Colbert, the woman behind the curtain, our invaluable administrative assistant to the board. Nothing that happened here this weekend would have been possible without her, as well as Victor Rauscher, admin services and IT, for providing rooms and technical support. And to this lovely group of people, the Moot Court board, my collaborators, my support system throughout this entire weekend. You've put in many long hours, and it ran so smoothly, and it was all because of you. And I'm very lucky to call you all my friends. Finally, Noah Chase and Joe Anise, your outstanding help organizing judges, bailiffs, food, generally brainstorming with me throughout this entire year. I couldn't have made this happen without the two of you. You've worked so hard and sacrificed so much of your time and energy, and I appreciate it a lot. And now I would like to introduce our esteemed panel of judges. And everyone, please rise for the judges. Lovely to see you all. Thank you all for being here. All right. So to begin, here in the middle, we have the Honorable Leslie E. Stein from the class of '81. Judge Stein currently serves as the director of the Government Law Center here at the law school after she retired as the associate judge of the New York State Court of Appeals in 2021. Judge Stein began her legal career as the law clerk to the Schenectady County Family Court judges. She also practiced matrimonial and family law with the Albany law firm of McNamee, Lochner, Titus, and Williams, where she made partner. In 1997, she left private practice to begin her judicial career as an Albany City Court judge and acting Albany County Family Court judge. She was elected to the New York State Supreme Court, 3rd Judicial District in 2002, and then appointed to the New York State Appellate Division, 3rd Department in 2008. In 2014, Judge Stein was nominated as an associate judge of the Court of Appeals, and she was confirmed by the New York State Senate in 2015. Judge Stein has also co-chaired the New York State Unified Court System Family Violence Task Force and has served as a member of the board of the New York Association of Women Judges. Judge Stein also has lectured and developed curricula for continuing legal education for attorneys and judges on multiple topics. Thank you, Judge. Judge Christine Clark to my right, from the class of '96. Judge Clark began her legal career at Dreyer Boyajian and as an associate. Shortly thereafter, she was offered a position by the Schenectady County District Attorney Robert M. Carney. At the Schenectady DA's office, Judge Clark began as a DWI prosecutor and then General Felony Bureau, and then became the sex crimes child abuse prosecutor, then to be promoted to become the first bureau chief of the Special Victims Unit. In that role, she helped establish the Schenectady County's Child Advocacy Center. In 2004, Judge Clark was appointed to Schenectady City Court Judge and then won the election to that position for a full term. In 2010, Judge Clark was elected as Schenectady County Family Court Judge. And then in 2012, she was elected to the New York State Supreme Court 4th Judicial District. She was the second woman ever elected as a Supreme Court Justice in that district. In 2014, Judge Clark was appointed to the Appellate Division 3rd Department, where she sits as a justice today. Judge Clark is married and has 2 daughters, ages 19 and 15. Judge Daniel Stewart to my left, from the class of '88. Judge Stewart, a native of Warren County, began his legal career as a trial attorney and partner, also at the law firm of Dreyer Boyajian, and stayed in that position for 15 years before he moved to Brennan and White LLP for 10 years. In 2015, Judge Stewart was appointed to the Northern District of New York, where he sits today as a United States Magistrate Judge. Judge Stewart has taught civil rights litigation at Albany Law School since 1995 and has lectured extensively on the law of Section 1983. Some insider knowledge information leads me to believe that he has climbed all of the Adirondack high peaks, and he is building a cabin with his brother. Judge Walsh, also on my left, graduated from the University of New York Law School in 1990. She began her legal career in private practice, concentrating in family and matrimonial law, as well as serving as an attorney for the child and assigned counsel for adults in Rensselaer County Family Court. In 1996, Judge Walsh served as the president of the Troy City Council and as an at-large representative since 2000. In 2009, Judge Walsh was elected to the Rensselaer County Family Court and was re-elected to the bench in 2019 and currently sits there today. Judge Walsh is currently developing a family treatment court for Rensselaer County under a 3-year grant. In 2023, Judge Walsh was appointed as acting Supreme Court Justice. Judge Walsh is married to Judge Christopher T. Mayer, who is the Troy City Court Judge and supervising judge of all city court judges in the 3rd Judicial District. They have 2 children, Thomas and Eric. And Judge Richard Rivera, class of '91. Judge Rivera began his legal career as associate counsel for the law office of Gaspar Castillo, where he represented litigants in local, city, and town courts, handling criminal matters, traffic violations, and appeals. Judge Rivera began his career in family court when he became staff counsel for the Albany Law School Family Violence Clinic. In this position, Judge Rivera represented victims of domestic violence with all matters pertaining to orders of protection, custody, and support. Judge Rivera also served as attorney for the child in Albany and Rensselaer counties, assistant conflict defender representing litigants in family and criminal matters, and associate county attorney prosecuting juvenile delinquents and PINs, and also served as support magistrate. In 2014, Judge Rivera was elected to Albany County Family Court and was the first person of color elected to a countywide bench and the first Latino elected to any bench in the entire 3rd Judicial District. In 2017, Judge Rivera was appointed to preside over the newly created domestic violence part at the Albany County Family Court. In 2018, Judge Rivera also began presiding over the Albany County Youth part since creating since its creating pursuant to the Raise the Age legislation. In 2019, Judge Rivera was designated acting Supreme Court Justice for the Third Judicial District, also being named the first supervising judge for domestic violence courts and mentor courts. In 2022, Judge Rivera was appointed supervising family court judge to the Third Judicial District and was the first person of color to hold that position. Shortly thereafter, Judge Rivera was appointed to co-chair the Franklin H. Williams Judicial Commission, which was established to develop programs to improve the perception of fairness within the court system and ensure equal justice in New York State. And without further ado, I turn the competition over to our extremely distinguished panel of judges. Thank you all.
Start with the appellant.
Your honors, may I proceed?
Yes, you may.
Good afternoon, your honors. My name is Celia Garrett. May it please the court. My name is Celia Garrett on behalf of petitioner Nicholas P. We would like to reserve 1 minute for rebuttal. I will argue that the child's best interests are served by granting the father custody. Co-counsel Linda Kate Gilbreth will argue in support of the father's right to make healthcare decisions for his children. Antonia needs stability and security, and her father is best positioned to provide that. This court should reverse the appellate division for 3 reasons.
Before we start and get into the substance of it, what is the standard of our review? Was it substantial basis in the record? Do we have to give deference to the findings of fact of the courts below, or help us out with that?
Your Honor, the appellate courts are to give the trial court deference in its factual and independent determinations that are made. The standard for review is abuse of discretion or finding that the trial court's decision lacked a sound and substantial basis in the record, which here is not the case. Pennsylvania case Johns versus Chiocci notes that this includes the trial court being best positioned to evaluate the appropriate weight given to the child's preference. And for that reason, the appellate court in this case abused there is no abuse of discretion in this case for inadequately considering the child's preference. As noted in the record, there was a 5-day hearing conducted in July of 2022. Lincoln hearings were conducted with both children. And the reason for this deference is that the hearing court is best positioned.
Did the trial court take into consideration the child's wishes? Do we know that from the court's decision?
Your Honor, the trial court does not give significant discussion room to the child's preference in its opinion. However, it does note that these hearings were conducted and the appellate division cites without noting any deficiency in factual evidence or record to the trial court's determinations. And as this is a balancing of the various factors that weigh in determining Antonia's best interest, the trial court took several factors into account. And this leads me to my first point, that her father's financial security increases stability for the child.
Doesn't the fact, though, that the father hadn't seen the child in 3 years and the parents allowed the children's wishes when they were only 11 to control what they felt was in the best interest at that time, to have the children visit together with each other each summer?
Your Honor, 2 points to that. First, the father has not seen his child in 3 years because per the alternating visitation agreement, whereby the children would spend alternating summers with the mother and father, the father was due to have the children in the summer of 2020 and made a calculated decision with the best interests of his children at heart that Antonia should not travel. And secondly, although the children, as you've noted, have expressed this preference, The parents have been adequately responsive to the preferences of the children. They altered the visitation agreement and made that agreement be put in place at the insistence of the children, as noted by the appellate division, thus showing firstly that the parents are responsive to preferences and needs indicated by that child. And
But the child has indicated that she would like to stay with the mother, correct? And the trial court doesn't really articulate in any length as to how that's weighed. Is that a defect for us?
Your Honor, 2 points to that. First, I would note that Antonia has also indicated on the record at page 18 that she misses her sister, and the mother has also testified, as noted on the record at page 9, that she believes it's important for the children at this point to grow up together. Courts, for example, the New York Court of Appeals in Dintroff versus McGreevy, have listened to children's preferences and ultimately determined not to follow those children's preferences. For example, the New York Court of Appeals in Eschbach versus Eschbach highlighted that a child's preference is not determinative and is simply one factor to be balanced in this overall best interests analysis.
What do we do with the fact that the child's, particularly relative to her silent child syndrome, has a lot of trouble with transitions? And if she hasn't seen the father in 3 years, how is she going to make this transition to him?
Your Honor, I'm glad that you raised this issue of Antonia's particular needs, because they indicate a greater need for stability in the long term than other children. The court in Obe versus Degling indicated that custody should be established on a long-term basis to further stability. And given the father's financial security, as well as the familial support structure that is in place at the father's home between his wife, his wife's mother, who is down the road, and Hallie, the sister, the father's home provides that long-term stability that at this point is in Antonia's best interest.
How do
So
you,
aren't we penalizing the mother because her financial situation may not be as great and she may not have someone else? It seems like we're comparing the two households unfairly.
Your Honor, the economic considerations alone are not the only factors that weigh in favor of the father being best suited for Antonia at this time. And we do not today request that the mother be penalized for her financial situation. 2 points to that is first, that Antonia's special needs in this case indicate that she would greatly benefit from the specialists and other developmental opportunities that the father is not only financially able to provide, but due to his proximity to these specialists for a child with such a rare disorder, he is also able to offer Antonia greater medical and therapeutic benefits. And
Counselor, I'm
second,
not sure where in the record it shows that those needs are not being adequately met while this child resides with her mother.
Your Honor, Antonia is receiving adequate medical care with her mother right now, and the father has attested to that. However, the standard before the court today is not a minimum safety standard or simply adequate medical care, but what is in Antonia's best interests. And what is in her best interest at this point is the medical specialist and practitioner that has this very particular specialized knowledge about silent child syndrome, the treatment for
How
child.
do you outweigh that with the fact that this child is so bonded with her mother?
Your Honor, this gets to the second point that I was going to answer, Judge Rivera's question. The mother's bond with Antonia is significant, and her visitation would not be barred or disrupted. The father wants to promote and continue that relationship. However, the father is also able to provide other emotional support at his home that weighs in favor of finding the father is best suited to care for Antonia. For example, not only does the father have a bonded and stable relationship with Antonia, as noted on the record at page 11, and the wife has testified that the two are quite close and despite the distance communicate very frequently. And Antonia is comfortable speaking verbally in front of the father, which as noted in the record, she does not do when anxious or uncomfortable. But moreover, the positive familial dynamics and the benefits of living in a two-parent home with her sister provide such emotional and intellectual support for the child and her development that this, while acknowledging that the mother has a strong bond with Antonia, weighs in favor of the father. For
What
example,
evidence in the record is there regarding Antonia's relationship with her stepmother? And how comfortable she is with that?
Your Honor, in the record at page 6, it was noted that the father's wife has a positive relationship with Antonia. And in the record also at page 6, it was noted that the father and his wife are willing and prepared to be with the children at home in the evening to help with homework, to attend this children's school events, and regularly meet with teachers. And
Are we saying that the mother is not able to do that or is not actually doing that now?
no, Your Honor, we are not contending that the mother is not doing that now. The benefits that Antonia will reap from being with her sister simply tip the analysis of best interests and weighing these factors in favor of the father.
It sounds like what you're saying is that the father and his household can provide what the mother is already providing. So how does that make it better?
Your Honor, courts, for example, in Eschbach versus Eschbach, in Ebert versus Ebert, 2 New York Court of Appeals cases, note that the court has long recognized it is in the child's best interest often to live with their sibling because it promotes stability, companionship, as well as other factors that are not present between the mother and the daughter, such as building identity, as well as encouraging healthy adjustments to and with others, particularly to peers. And given Antonia's—
But counsel, weren't they already living apart for a number of years? I mean, this was a decision they made when they separated. Each one takes one.
Yes, Your Honor. First, to that point, the 2009 separation agreement, as noted in the record at page 4, was made in part because they said, Your Honors, I see my time is elapsed. Can I briefly finish the question and conclude?
Yes, you may.
They noted that in the separation agreement, part of this was because they had determined that the twins were too much for one parent to handle alone, and that is no longer the case at the father's house. And for the foregoing reasons, because of the financial security, the emotional support, and this family structure that is in place at Antonia's, the father's home environment will best promote stability for Antonia in the long term and provide her with the requisite care that she needs as she ages and medical needs of hers change.
Thank you, counsel.
Respectfully urge you that reverse the appellate division. Thank you so much.
Thank you.
Your Honors, may I proceed?
Yes, you may.
Good afternoon, Your Honors, and may it please the court. Linda Kate Gilbreth for the petitioner. Here we have a 14-year-old child who has decided she wants to go on a long-term hormonal medication without fully understanding how it may interact with her rare pre-existing condition.
Well, isn't the mother just asking for a consult with a doctor who's qualified to find that very information out?
Yes, Your Honor, the mother is asking for a consult with the doctor, but the mother
You're
is,
objecting to that.
yes, Your Honor, because the mother is not authorized to do that by the party's contract or by the statutes of the state of New Scotland. This court should reverse the appellate decision and find that the father and only the father is allowed to make these decisions for his children for 4 reasons.
Is that for, even for a father who's had no contact with his child, no in-person contact with this very child for 3 years? How do you square that with your position?
Yes, Your Honor, even for a father who has not had in-person contact with his child for 3 years. Maria, his wife, testifies on record page 7 that he and Antonia have a significant texting relationship. They are in frequent communication, even if they are not physically together. Furthermore, he is aware of her goings on. She did inform him of her wish to start taking birth control. The record at page 19 shows this. So he is aware, she is communicating with him. She's clearly comfortable raising these issues with him. But at the end of the day, the father has the legal custody over medical decisions. And furthermore,
That raises a point that I find it curious that, and a little bit unusual, that the parents' agreement says that there does not have to be a substantial change in circumstances to warrant a change in custody. So if that's the case, then why wouldn't the mother be able to obtain the right to make medical decisions for Antonia?
because, Your Honor, the father remains qualified to be making these decisions, and it still is in the best interest of the child. And if we're not looking to a change in circumstances, we are looking to the best interest of the child.
I have another question though about this particular medication, and it's being referred to as contraceptive medication, right? But there's no indication in the record that that is the purpose for which it would be used, right? So shouldn't we be looking at it through a slightly different lens?
Your Honor, that is exactly the lens with which we should be looking at it. It is not contraceptive. It is, in this case, she is using it as a pain medication. She's using it to manage pain. This isn't about reproductive rights. This is about a father's ability to make decisions for his child with respect to how she deals with pain she's experiencing.
So if it's not about reproductive rights, then does public health law section 381 apply at all?
Yes, Your Honor, it does still apply because any physician that's prescribing birth control will have to comply with section 381. Because while Antonia is not seeking to prevent pregnancy, birth control is still technically medically a contraceptive.
And just so I'm clear about the statute says in order to provide information with regard to not contraception itself, but just information to the child and to the child's mother about contraception, they would need the consent of the father. Is that your reading of the statute?
Absolutely, Your Honor.
Well, let me ask you this, when the child complained to the father about having the cramps and did the father take any action to have her seen by a qualified doctor at that point in time? It was the mother who did that, correct?
Your Honor, it's not clear from the record exactly when Antonia did disclose this to her father, but knowing this information, he did find a silent child syndrome specialist in New York who he has said on the top of page 20 in the record, he wants to have evaluate Antonia for this issue of whether or not it is in her best interest to take birth control.
Then why has he waited so long? He hasn't seen the child in 3 years. And the child had this issue pre-pandemic. In fact, that's when the mother was that's when the child approached her mom. So how is it, how is that in this child's best interest that dad waited 3 years with a child who's in enough pain that her teachers say it interferes with her learning and her activities, and her mother says she can hardly move from it?
Your Honor, that speaks more to the mother's unwillingness to communicate with the father about this issue. Again, in the record, when the father states on page 19 of the record that Antonia informed him she wanted to begin taking birth control, it's not exactly clear when that happened, but it is clear that Antonia told her mother she wanted to start taking birth control for this extreme menstrual pain pre-COVID-19 pandemic. All the mother needed to do was pick up the phone and consult the father.
Do you really need parental consent here? I mean, when you look at the section that talks about the child may suffer probable health hazards without such information, it seems to me that she's suffering a lot currently with a health problem with the menstrual cramps. Could we just say this doesn't apply, that they didn't need consent of a parent?
We could not say that in this case, Your Honor, for two reasons. First, the trial court, the fact finder, did find that she actually does not suffer a probable health hazard under section 381 of the New Scotland Public Health Law. But furthermore, this is something that the father is considering in the context of her broader healthcare, in the context of all of the healthcare that she is receiving. And the risk with taking hormonal birth control is that it would negatively interact with her silent child syndrome treatment and development.
But there was no evidence of that in the record, correct? I mean, they were only at the stage of beginning to look at this issue. This wasn't, they haven't consulted with the doctor yet. So how do we know that?
Well, 2 points on that, Your Honor. They haven't consulted with the doctor because the mother isn't authorized to make a switch of the doctors without the father's consent. But furthermore, we do have basis for concern. The father has basis to be concerned about the impacts on this child with her specific needs.
Is there any evidence that the mother would not have agreed to consult with this expert or anybody else before actually coming to the decision of whether we should have the medication or not?
No, Your Honor, there isn't evidence of that.
So isn't this a little premature, really? And also under the statute, it refers to the parent and apparently refers to the custodial parent. So who's the custodial parent here? Isn't it the mother?
Well, to Your Honor's first question about whether this is premature, this is not premature because the father has to be able to enjoin the mother's actions when she seeks to take unilateral action of switching Antonia from her primary care doctor, who from the record, she's been seeing her whole life, to a gynecologist at Sealy. So the father needs to be able to enforce the private agreement that the parties made in 2009 before it gets so far as prescribing Antonia a hormonal medication that may be harmful for her. And furthermore, to your question about custody and who is the primary custodial parent, Section 381, when listing a general preference for the primary custodial parent, does not specify exactly what it means. And of course, we have a physical custodian, but we also have a legal custodian. And here, the father is a
Doesn't
legal.
it seem to indicate it's talking about physical custody though, because it says the custodial parent, it talks about the custodial parent's availability. And then the issue, the court would then have to consider going on to those next issues. So it seems to me that it's talking about the physical custodian.
Not necessarily, Your Honor. And in this case, the father does have legal custody over this sphere of influence of medical decision-making. So he would be the primary legal custodian for this specific application.
And they had joint legal custody otherwise, right? He just had final decision-making power.
He has final decision-making power over multiple major matters impacting.
So if she had joint legal custody, could she not seek out certain things? And then when it became to the final decision-making, that dad then would decide if they were not in agreement?
Of course, Your Honor, she can make inquiries. She is allowed to ask questions of doctors, but she cannot switch Antonia to a different doctor. She cannot.
Done that?
She didn't do that.
She has not done that, Your Honor. And that is why we're here today, to prevent her from taking action that violates the party separation agreement, which at this time, no final moves have been made. But
So is there any evidence in the record that the father included her when he was searching out a specialist in that decision?
no, Your Honor, but also Antonia has not seen that specialist either. This is a specialist that the father has found who is an expert in developmental disorders like Antonia's. He is simply seeking the best medical health care, the best healthcare available to his child.
Does
And-
that really require a change in physical custody, though? They live 2.5 hours away. Couldn't the child still continue to live with the mother and travel to the father's home city and see specialists? In fact, they both could, right? The mother and the child both.
It would be possible, Your Honor. It would be difficult. However, it would be very disruptive to Antonia. And we know Antonia.
Would it be disruptive to Antonia to move 2.5 hours away from her mother already?
Yes, Your Honor, that would be a short-term disruption with long-term benefits, as my co-counsel has previously noted. But furthermore, looking deeper into the statute, Section 381 of the New Scotland Public Health Law.
Before we go into that, you mentioned Antonia. Doesn't she have a constitutional right to seek contraceptive services? First of all, is she 14, 15?
She's 14, Your Honor.
And she doesn't have gynecological services that have been provided to her at all at this point in time, according to the record?
Not yet, Your Honor.
But does she have a constitutional right to seek out contraceptive?
She has a constitutional right to privacy in decisions whether to bear or beget a child. That is the constitutional right that was established in Eisenstadt v. Baird and extended to minors and Carey v. Population Services International. But that's not what's at stake here. To Your Honor's first question, this is about pain management. This isn't about reproduction. This isn't about reproductive privacy. It's about what she can do to relieve pain she's experiencing. And when the court is looking to whether to accept the mother's non-custodial parent written consent, we have to balance 3 factors: the father's availability, the best interest of the child, and the liberty interest. And since there's not clearly an
I need to have you explain a little bit more why you refer to her as the non-custodial parent. Is it because of this one carve out that the father gets to make the medical decisions?
Yes, Your Honor, because providing written consent for somebody to receive a birth control information or prescription would be a major matter of healthcare. So that would be making a decision about what healthcare a child is
But
going.
the mother has not done it.
No, Your Honor.
And the mother is seeking to have the right to make that decision in,
Yes.
in this very proceeding, correct?
Yes,
So why shouldn't she have that right?
she shouldn't have that right, Your Honor, because she isn't considering the specialized needs that Antonia has.
How do we know that, counsel? How do we know that she's not?
Your Honors, I see my time has elapsed. May I briefly answer the question
Of
and
course.
conclude?
Yeah.
Thank you. Your Honor, we know that she's not because as soon as Antonia asked her about birth control, she went and found a birth control that she wanted Antonia to go on. And in 1997, the Third Appellate Division of New York in Brewer v. Whitney determined that when parents disregard the specialized needs that result from their children's developmental disorders, developmental disabilities, they may not be best suited to be making those decisions in the first place because these are complicated matters that have serious implications for their children's health and well-being. And for the foregoing reasons, Your Honors, we respectfully urge this court to reverse the appellate decision on both issues. Thank you.
Thank you, Counselor.
May it please the court. Good evening, Your Honors. My name is John Kelly. Along with my co-counsel Kyle Westerfer, we represent the respondent, Ms. Eliza J. We request that this court affirms the decision of the appellate court, which correctly decided that relocation to New York was not in the minor child Antonia's best interest, and that Antonia's mother was best fit to address her medical and liberty interests. I will.
Would you help me out here a little bit? Because this doesn't fit the usual framework of a relocation case, which is where the custodial parent is seeking to move with the child. And to make it, I think, even a little more complicated is the fact that it is the question of whether, with or without the relocation issue, right? With or without tropia, the ultimate determination is best interest of the child, right?
Yes, Justice Stein.
And so what is the difference in those analyses? Is there really any difference?
Justice Stein, the respondent doesn't see a difference as it relates to this specific case and as it relates to the analogous case law mentioned by yourself as it relates to tropea. It's the respondent's point that the appellate court was correct when it held that relocation to New York was not in the child's best interest for the following two reasons. First, Antonia's bond to her mother and to her community highlight that her best interests are served by remaining in New Scotland. And second, the appellate court correctly gave advanced weight to the wishes of the minor child. Turning to my first point, the respondent requests that this court adheres to the reasoning provided in regard marriage of Hansen, decided by the Iowa Supreme Court in 2007. In that case, the court concluded that a primary caregiver should be given preference in a relocation case because they best provide for the continued continuity and stability of the child's life. Similar to the mother in that case, Eliza has been.
Can I ask you a preliminary question?
Yes.
So we're in appellate court. We didn't get to see any of the witnesses testify. We didn't get to judge their demeanor with regard to that, how credible that they seemed. The judge that did see that ruled against you. So why isn't that entitled to significant weight, that determination?
Yes, Justice Stewart. The court in matter of James T.T. v. Shermake UU decided by the New York Appellate Division in 2020 reasoned that a decision made by the trial court can be disturbed if there is not a sound and substantial basis in the record that would warrant relocation or a petition for the custody order. And as the respondent's point that is exactly the case here. As mentioned, the bond that Antonia has established with her mother and also with her community highlights that she is best off remaining in New Scotland. The trial.
Counselor, your opponents made a good point. The father has greater stability. He has, his wife has a good relationship with the child. He's got the grandmother. He's got a specialist. I mean, shouldn't we consider all those things and allow this child to go stay with her father?
Justice Rivera, while the record does reflect that Antonia has loved ones in New York, it also reflects that everything that has been made available to her in New York can also be made available to her in New Scotland.
I
However,
know that for sure.
yes, Justice Rivera, the child has expressed the desire to remain with her mother in New Scotland based on the fact that she's been involved in numerous activities such as fencing, joining a swimming team, and even engaging in writing workshops. This highlights the fact that the child has engaged with her peers and has begun to start a new life in New Scotland that's conducive to her continued growth and to her development.
But she also misses her sister.
Yes, Justice Rivera, she does miss her sister. However, there is a crucial distinction here. Hallie is also at the age of 15. She cannot be considered as a caregiver for this child. And while she also has a bond with her father, there's a crucial distinction here as well. The father is not and has never been the primary caregiver for this child. This title has always lied with the mother. And for these reasons, the child has expressed the desire to remain in New Scotland. Opposing counsel suggests that her life would mirror a more stable image based on the fact that the father can offer financial security.
The
However,
trial court seemed to really reflect on the fact that there was still co-sleeping going on with your client and the child. And do we have to defer to that credibility determination? I mean, it seemed that the court was very disturbed by that as the mother wasn't maybe properly handling the child in some instances.
yes, Justice Clark. However, in the appellate court's decision on page 24 of the record, that the mother has taken steps to access therapeutic help and mental health services, not only for the child, but also for herself, so she can gain the necessary resources and tools to abate this issue. Furthermore, it also does show that at this current moment, the child is extremely dependent on her mother as a result of the bond she has established with her. The record on page 9 reflects that this child drastically suffers from sudden changes. There is no greater sudden change than uprooting the life of a 15-year-old at this point and relocating her to a place that she has never lived or never has spent more time than just a summer or a few weeks.
Counselor, what if any bearing on this issue of best interest and determining whether there should be a change here? What if any bearing on that question is the fact that the parents agreed that there need not be a material change in circumstances to warrant a change in the custodial arrangement?
Yes, Justice Stein. However, as respondent would rely on, this would not just be considered a material change, it would be a drastic change. This child has been fortunate enough to spend her whole life in one community and set down her roots in this community. Simply offering a relocation on behalf of the appellant as a result of finances alone would lead courts across this country to make cases, decide cases in favor of a parent who provides a better financial situation. If that were the case, every indigent parent across this country would be left powerless.
That wasn't the only factor that the court considered. There were others, such as the relationship between the two siblings and the stability of the father and things like that.
Yes, Justice Stein,
So how do we look at it? Are we doing the weighing here, or are we looking at whether or not the weighing that was done in the trial court was supported by the record, essentially?
yes, Justice Stein, we would ask that this court looks at that record and determines that there is no sound and substantial basis that would warrant relocation. As it relates to what.
Why is that? Because the continuity of where the child has been and her preference outweighs everything else? Is that why you make that conclusion?
Not only for these reasons, Justice Stein, however, the New Scotland Family Law Act itself has been modeled after the Domestic Relations Code in the state of Delaware, which also addresses the child's adjustment to his or her home, school, and community. The record shows that if uprooted, this child would have to move 3.5 hours away. And it is hard for any teenager, let alone one with special needs, to undergo this sudden change. So based on the fact that she does have this bond with her mother, that she has experienced success in her community and has expressed a wish to remain, yes, the respondent would assert that all of these taken in the totality of the circumstances suggest that her best interest remains serving.
But what about her medical needs? Because, I mean, you keep saying it's drastic, but it's not like she doesn't know her father. It's not like she doesn't know the home. It's not like she's never been there. She's never visited, but she's got medical needs.
Yes, Justice Rivera, she does. However, the respondent does not have an issue with the child seeing this doctor because of the fact that pursuant to the modification to the custody order that occurred in 2019, the child is able to spend summers in New York. Therefore, there would be no issue on behalf of the respondent for this child to see the specialist when she is in New York. This can still be achieved without uprooting her life and making her move to a home that she has never lived in. And on page,
Well, my concern is that she had signed this agreement where these types of significant medical decisions were going to be, the final decision maker would be the father. Setting that aside, not consulting with the father, not picking up the phone and saying, look, this is what we want to do. We want to see a new doctor. We want birth control for these reasons. Shouldn't that be a factor that we consider?
yes, Justice Stewart, and the respondent would point to the fact that when this issue of menstrual cramps arose, the first instinct of the child was to go to her mother, not to her father, but to the person that she trusts the most, who she spent the entirety of her life with. And as it relates to medical services, the father himself, on page 20 of the record, admitted that the doctors at Sealy Medical are equally qualified to practice medicine. Therefore, they can treat her at Sealy Medical, or if the appellant desires, this child can see the specialist in New York when she travels there for the summer. Turning to my last point, Your Honors, the appellate court's decision to give enhanced weight to Antonia's wishes was correct. In Anthony Y.Y. v. Emily Z.Z. decided by the New York Appellate Division in 2020, the court concluded that if a child reaches an advanced age, such as 14, their wishes should count for more. The respondent would assert that this should be taken into account even to another level because of the fact that the child has special needs. If she were to be relocated, her condition can worsen, and this would be an unnecessary burden that doesn't need to occur. The father may have a lot to offer in the way of finances, but he cannot offer the comfort of the established routine the child has set down in New Scotland. He cannot offer the bond that she has established with her teachers, her classmates, and her friends.
Wouldn't the fact though that her sibling would be residing with her take away from some of that disruption, since they would be, I presume, going to school together, doing a lot of things together?
Yes, Justice Walsh, but Antonia did take this into account because she still expressed the desire to remain in New Scotland. The father simply cannot offer the lifelong bond that's been established between this mother and her child. When she visits her father's house, she is just at her father's house. When she is in New Scotland, she is home. Your Honors, the respondent requests that this court honors Antonia's wishes. Please do not remove this child from the only home she has ever known.
Thank you.
Thank you for your time, Your Honors.
Sir?
Good evening, Your Honors. My name is Kyle Westerfer, and I will be addressing the second issue here tonight, which deals with the allocation of final decision-making authority and the constitutionality of New Scotland public health laws, sections 380 and 381. Tonight, Your Honors, we're asking that this court uphold the Third Appellate Division's conclusion for two reasons. First, Respondent Eliza is currently best fit to have final decision-making authority over Antonia's medical decisions, including her ability to obtain birth control pills.
Why are we talking about birth control? It's not as if this is a child that is or wants to be sexually active, or that really there's any relationship here to the desire to use this medication as birth control or contraception. So why is this even part of the analysis?
Yes, Your Honor, we're fully in agreement with your point about the practical medical purpose of these. But unfortunately, the reality is they're part and parcel with the medicine that's given. What will always work for treating menstrual cramps will also always be a contraceptive service. And particularly as it relates to today's case, while sections 381 of New Scotland public health laws deal specifically with contraceptive services, sections 380 deal with medical and prescriptive medicine in terms of minors treatments. And both of those require parental consent, which brings us to the second issue, the second point tonight, which is that sections 380 and 381 directly violate Antonia's liberty interests.
The counsel, well, before we even get there, your client was required to get the consent of the father, or at least have a discussion. He had final decision-making authority, so she was violating the public health law, that's section 380, wasn't she?
No, Your Honor, that's not an understanding. Unless you're referencing the previous agreement between the parties, or specifically the language of the statute.
The language of the statute.
No, Your Honor, it's not our contention that she was in violation of section 380, simply because we were in an investigative period when Eliza had gone and spoken to the doctors. There was no decision that was made. There was no attempt to effectuate a final change. She was merely obtaining information as she could go then and possibly consult with Nicholas per their agreement that they had
Possibly, but
contractually.
we don't really know that, do we? Because
Your Honor-
she didn't consult with him before she even went to get the advice.
No, Your Honor, she didn't. But Eliza has been the primary caregiver of Antonia for 14 years. And specifically since Antonia has turned 14, Eliza's had to watch Antonia suffer intense menstrual cramps.
So are you saying that she's been making these decisions without consulting the father?
No, Your Honor, again, there was no decision that was reached. Eliza had asked the doctor for information about potentially switching to a different medical facility, assumably, and with a good faith basis, to believe that that would then go to Nicholas, because there's been no contravention of the agreement up to this point. I don't know what the conversation would look like without the information potentially that Eliza was seeking to get before going to Nicholas.
Do you agree with your adversary that the mother is not the custodial parent of Antonia?
Your Honor, she's the yes, Justice Stein, she's the primary custodian in terms of the care that she provides. But in terms of the legal custody, that being the decision-making authority, she does not have that custody.
So how do we ascertain what the meaning and intent of the statute is when it refers to the custodial parent?
Your Honor, we're not entirely sure as well, but turning to the statutes specifically, sections 381 and 380 both require some form of parental consent. And jumping into the constitutionality arguments now, Your Honors, we believe that it's a requirement of parental consent across both of these that specifically makes this statute unconstitutional. Specifically.
And why would that be?
Yes, Your Honors, because in Griswold versus Connecticut, the Supreme Court established the 14th Amendment right to privacy as it relates to adults obtaining contraceptive services.
Go ahead.
Was there a deeply rooted historical tradition in the 1830s for a 14-year-old to get contraception?
No, Your Honor, there wasn't in the 1830s, but it's since been extended to minors in Carey versus population
Right,
services.
but when you look at Dobbs, it seems that they're obliterating that case too, aren't they?
No, Your Honors. Specifically, Justice Alito in the majority decision made clear that this does not affect, or Dobbs' decision does not affect the line of cases such as Griswold. Justice Alito even specifically wrote, quote, "Nothing in this opinion should be understood to cast doubt in precedents that do not concern abortion."
Well, Eisenstadt versus Baird specifically says the reason we're giving minors the ability to have contraceptive is because they have a constitutional right to have an abortion. That's the foundational basis for that decision. So if that's gone, isn't the follow-up with regard to the right to have contraception gone as well?
No, Your Honors, and because Carey versus Population Services International still remains. In that case decided by the Supreme Court in 1977, the court struck down a New York law which provided a near blanket prohibition on a minor's ability to obtain contraceptive services. When saying that statute, even with a narrow exception where physicians can still prescribe such, failed constitutionality, said in order for a statute to pass, it must, quote, "be justified only by compelling state interest. It must be narrowly drawn to express those interests."
So, but
And-
are we talking about the privacy interest that was involved in those cases, which was the right to decide whether or not to give birth, essentially, right? And is that the question before us in this case? Does that whole body of case law even apply here?
Yes, Your Honors, yes,
We're
Justice
talking
Stein.
about a pain medication.
Well, Justice Stein, while we're talking about the practical use of it as a pain for pain purposes, there's also that reality and that inextricable function of it also regulating menstrual cycles and the ability to bear children. So they will always be one and the same.
But that's not what Antonia is seeking here, is the right to make those decisions at this time. For all we know, when she becomes the childbearing age and interest, she may decide she wants to stop taking this medication.
Truly, Your Honor, that is definitely a possibility. But it's our contention here today that the requirement of parental consent in both 381 and 380 are exactly what make these statutes fail under that violate Antonia's liberty interest. Because of the constitutional protection that a minor has to engage in contraceptive services, which birth control is, anything that would stop that is a violation of their constitution protected activity.
What wasn't though Carey versus Population Services, that was for children who were 16 or over, correct?
Yes, Your Honors, it was for 16 or over.
So if it was a 10-year-old, would consent also not be required?
Your Honors, we're not in a position to advocate for a specific age or a specific number. As Supreme Court,
Your Antonia's what, 14 or 15?
She's 15 at this time, Your Honor. And specifically, Your Honors, while parents do have a legitimate constitutional interest in making medical decisions regarding their children, there's also that constitutional protection for minors. And when federal courts have been called upon to balance these interests, the child's right to obtain contraceptive services has always won out. Such as in TH versus Jones, decided in Utah Central District in 1975, the court struck down a law that required parental consent before a child could obtain contraceptive services. Similarly, Doe versus Erwin, which was a lower standard statutorily required, that being parental notice, the child's interest still won out. And the Sixth Circuit held that even requiring parental notice was unconstitutional. It is specifically for these reasons, Your Honors, that we're asking that this court find sections 380 and 381 are unconstitutional. Turning now to the second issue, and that's regarding the allocation of final decision-making authority regarding Antonia's medical decisions. Sections 248 of the New Scotland Public Health Laws give this court the inherent power to make a modification of a prior custody order and a prior legal custody agreement, so long as that modification is within the best interest of the child. Specifically, in Melissa C.D. versus Renee I.D., decided by the New York Appellate Division in 2014, the court established a multi-factor test to determine if a proposed change in legal custody best fits the best interest of the child. One of those factors was the relative fitness of the prospective parents. As Your Honors have heard today, Antonia suffers from a condition called silent child syndrome. It's an anxiety-based disorder which inhibits her ability to effectively communicate with others. And since turning 14, Antonia has also begun to experience intense menstrual cramps. These cramps have had a negative, palpable impact on her life. She's been unable to attend extracurricular activities, and this pain exacerbates the outburst she experienced because of her silent child syndrome.
What's the difference in the fitness of the parents, which you just led your argument with? You said that one of the factors is the fitness of the parents that is considered. What's the difference in fitness of this mother versus this father?
Yes, Your Honor, the difference in the fitness is the relationship that Eliza has been able to foster with Antonia. Eliza has seen her day in and day out for 14 years. Even when Antonia has a disability that affects her ability to communicate with others, she speaks at home with Eliza. And in the wake of these debilitating menstrual cramps, she didn't first turn to her father, she didn't turn to her sister, she turned to her mother. And she didn't just turn to her mother to say, I want to take them. She turned to her to discuss the possibility of taking them. And is the fitness of this close relationship that puts her in the best position to be able to make this medical decision.
But again, she went to the mom. The mom had an obligation to agreement that she agreed to talk with the father with regard to this, correct? Isn't part of fitness the ability to maintain or promote relationships between the child and the other spouse? Isn't that something that wasn't done in this case? Basically, the father found out about it through talking with one of the nurses, correct? That there'd been a change of doctors that he had no idea about.
Your Honor, Your Honor, to your point, there was no change of doctors that was effectuated.
Well,
It was
there
upon
an
the,
attempt.
yes, Your Honor, it was upon just asking for the information that the father was then contacted. We don't believe that there was any sufficient amount of time to even reach that. But to Your Honor's point even further, the fitness of this case, or the fitness of this parent relates to the change in circumstance of when Antonia, where she was when this agreement was reached and where she is now. What worked when Antonia was 4 no longer works now that she's 14. There's nobody in a better position to understand this transition from a young girl into a woman than a mother. And it's specifically because of this fitness that we're asking this court grant and allocate the final decision-making authority over Antonia's medical decisions to Eliza. Your Honors, thank you for your time. And if there's no further questions.
Thank you.
Thank you.
Your honors, may I proceed?
Yes, ma'am.
Counsel, how would you counter your opponent's argument on relative fitness and that their client is more fit?
Your honor, the father has been given the position to make the determination as to Antonia's medical care by the parties, and the father has shown that it is not in her best interest to take birth control at this time because he is right to be concerned about birth control's
He
effects.
hasn't said that she shouldn't receive this medication. He's just said he wants further information before that decision is made, right?
Exactly, your honor. A common side effect of synthetic estrogen and progesterone is depression, anxiety, and mood swings. Antonia is uniquely sensitive to changes in her environment and comfort level, as noted on the record at page 23. And for this reason, the father is concerned about the effects that such a medication would have and the interactions with her current, your honors, my time is elapsed. May I briefly conclude?
Sure.
Is concerned about these interactions and for that reason wants to see the silent child specialist. And for these reasons, as well as previously stated reasons, we respectfully urge this court to reverse the appellate division. Thank you very much.
Thank you, Counselor.
All right, the judges are going to deliberate in the judges' room, and we will eagerly await their results. Congratulations to you. All right, while the judges take their recess. I will bring the judges out.
Please be seated. First, let me congratulate on behalf of all of us up here, all of you for having made it to this point. For me, I lost count of how many final rounds of this competition that I've judged, and I have always found it to be extremely difficult to pick a winner and a loser because there really is no winner and loser. You're all winners for being here this afternoon, and you all really did a fabulous job. So we all go back there and we have to turn your performances into numbers, and that's really hard to do. And really the numbers come out so close. But they tell us that we have to find a winner and a loser. So actually, a very dear person in my life who's also a lawyer has always said, he used to tell his children when he came home from a trial, if he didn't win, he'd say, I came in second. Think of it that way. So I guess I will announce the winning team and then we will we'll give you some feedback from among all of us. So by a margin, a small margin, we have reached a consensus that the winning team is the respondent mother team. And the team that came in second came in a very.
So let me just say this. First of all, I've never been an appellate judge. I'm a family court judge. And I didn't do a lot of appellate work. But I think that you are developing and have shown us great skill this afternoon for thinking on your feet, for being very knowledgeable, each of you, about the record, about the case law. I think we were a pretty hot bench and you responded very well to lots of different questions from the different judges up here. So that's sort of my general commendation. Good job. Good luck in your careers in law. Hope you enjoy every minute of it.
All right, I'll this is on. So tell me where you're from. Great here.
We're from the Delaware Law School.
But which where?
Delaware Law School, Delaware Law.
Okay, all right. Yeah, I mean, this is fun for us. In federal court, we don't do as much oral argument as I would like us to do. And really good oral argument like we saw this afternoon is really helpful to the court in deciding a case, because there's certain things that, we read all the materials, but you really presented it all in a very, very comprehensive way. You took a lot of incoming fire and you stood there very strong. It was really an impressive job. Plus, everybody was respectful to each other. The presentations were good. You hopefully, is there a reception after this? You guys will always be, it's always fun doing trials because at the end of the trial, you and your adversary, and you always have that together. And years later, you'll talk with them. Remember this trial that we did? It's really a significant thing because you put so much work into this, and we're really appreciative of what you do.
So I hear appellate arguments, that's my day job. And all four of you are absolutely ready to go, argue in any appellate court in New York or Delaware, or where you plan to go after you finish law school. The amount of preparation from all four of you was absolutely amazing. Your ability to cite to the record, and even when, different situations, Linda, I felt like we really hammered you, and Cecilia, you got thrown there at the end with the rebuttal. And both John and Kyle, Kyle, you did a good job bringing it back when we wanted to take you in a completely different direction. So I really enjoy seeing young lawyers, and when you have this level of skill, you're going to be a pleasure for any court that you appear before. So thank you.
I echo all that has been said. I'm a family court judge. I'm not an appellate court judge, but I did participate in appeals. And I tell contestants all the time, or the students that do this, I didn't get as far as you did. I didn't make it past the first round. Competed in two different, competitions. So you've gone much further than I did, right? So it does not determine whether you win or lose where your career goes, but it does give you that experience and does give you that confidence to know you're headed in the right direction. And I agree, you all did a great job When I did my first argument, I was so nervous that my knees were literally shaking. No one seemed that nervous. I couldn't see your knees, but you didn't seem that nervous. But you did a good job. I tried to throw you because I figured if you're gonna reserve, I'm gonna make sure that you address my question. But you all did a wonderful job and you're heading the right direction, and congratulations.
Yeah, and I, like Judge Clark, have presided over many appellate arguments and, and some amazing advocates, and you all are just as good as any of them. And actually what you did was harder because you had to learn and be prepared, probably all in the same day, to argue two different sides, which is but it is really good preparation, even though you won't have to do that in the real world, to prepare to know what your adversary is going to argue and be able to respond to that. But I thought your poise and your sticking to your arguments was really admirable under all this pressure. So thank you, and we wish you the best.
Yeah, congratulations.
So before we go down to the reception, thank you all judges. Just wait 1 second and congratulations to you both. I want to do some quick pictures for the competitors with the judges, and then we can go down and have the reception. And thank you all on Zoom for watching.